Sandy, for the general practitioner who may have a client that wants to do an oil or gas drilling lease, or perhaps a client that does not, what are some of the issues that they need to keep track of for that client? Let's start first with the client who does want to have a drilling lease.
Generally, you find the oil and gas deposits in the same areas where there are coal deposits. And one thing the lessor needs to know is whether the coal has been severed from the surface estate. If it has, the coal company does have the right to object to the location of the oil well. And he appeals to the chief of the Division of Mineral Resources Management in the Department of Natural Resources. And if the chief finds that the coal company's objections are well-founded, then the drilling permit will be denied.
Any other tips that you might have for that general practitioner, for the client who does want that drilling?
If they want the well to be a certain distance from their home or a property line, they ought to spell that out in the lease, because if it's not, then only minimum spacing requirements will apply, and the well may end up being closer to their home than they anticipated.
For the attorney who has the client who does not want drilling on their land, there is a provision in the law that allows for the drilling anyway. Can you explain a little bit about what that is and why that is?
Yes, those provisions would be mandatory pooling on a smaller scale, and on the larger scale it would be unitization. And generally the reason for these laws is to protect the rights of those who are not willing to participate in drilling the well. It's a protection of their correlative rights so that they are able to share in the royalty and the production that is occurring from the oil that's being drained from underneath their property.
So what is the process that someone would go through if they do not want the drilling on their land?
Well, they're entitled to a hearing. They would file paperwork with the Ohio Department of Natural Resources, Division of Mineral Resources Management. A hearing would be held, a decision made whether to pool their property or not, and then that would be appealable to the Oil and Gas Commission. However, under the statute, the chief of the division is charged with not only protecting correlative rights, but also ensuring for the efficient development of oil and gas. Generally, the commission will uphold the decision to mandatorily pool unless the landowner who is against the well can establish that they were not given a just and equitable offer, as were all the other participants. And as far as I know, that's the only basis that a decision to pool a property has been reversed by the commission.